or 3, go to prison. Those are your options.
So what if felony court doesn't accept me?
Oh, then you're going to do inpatient treatment or either go to prison. All right. So, Mr. Boyd,
Yes, ma'am.
here's the issue. I referred you to felony drug court, and I see that you say that you can't do it because it's too much to do, but they're recommending inpatient treatment for you. So either you're going into inpatient treatment, or if you don't want to do it, you can be revoked and go to prison.
Well, that wasn't an agreement with the attorney. The attorney, she and I, what I asked the attorney, Miss Christian, I said, well, the police officer beat me up. I went to the emergency room and I brought it to attention. I said, well, since I got beat up, and she showed me the police report, the police officer said that I fell from a gazebo.
All right. So here's the thing, Mr. Boyd. I've been a defense attorney, and this is what I always would tell my clients. Sometimes when they would tell me that they've been injured by the police, I would tell them the injury by the police, that may be a separate issue for you to file a civil suit, but that doesn't excuse a possession case. So you're here for possession of a controlled substance, penalty group 1 gram to 4 grams.
No.
According to the plea bargain agreement that you signed up for, they're going to take some items into consideration, which they did, which was an evading, and there's supposed to be a TAP evaluation. The TAP evaluation is a treatment alternative to incarceration program. Basically, what that is that someone discusses with you any addictions you have. And then what ends up happening is based upon the answers that you've given, based upon your history, they make a determination of whether you should do inpatient treatment or outpatient treatment. Their determination was that you do inpatient treatment. I always send people who have drug issues to felony drug court. Well, not always. I'd say like 90% of the time, because it's a good program. You're telling me you do not want felony drug court. I've read your letter where you say you can't do it because it's taking too much time out of your life. So since you don't want to do felony drug court and you refuse that, then the next step for you is for inpatient treatment. So those are your options. You can either do inpatient treatment or you can go to prison. So either way, you're going to be doing time. So do you want to do your time addressing your addiction issues, or do you just want to do your time as an inmate? It's completely up to you.
Well, from my understanding, I mean, my attorney said that I was going to be 5 years probation. She did not say that I was going to go to inpatient treatment.
All right. What do you think probation is?
Staying clean and reporting every month.
And as part of probation, I have to give you conditions so that you will be successful at probation. For example, if you have a drug issue, what would I look like giving you probation and saying, good luck to you, thank you? Probation is more than, here's a sheet of paper saying you're on probation, go live your life and do whatever you want to do. Probation is, you're on probation, you have to report, you have to provide clean UAs, you have to go to inpatient treatment. Those are conditions of probation. So those are your choices, Mr. Boyd. You can, 1, go to inpatient treatment, 2, see if felony drug court will accept you back, or 3, go to prison. Those are your options.
So what if felony court doesn't accept me?
Oh, then you're going to do inpatient treatment or either go to prison.
That's crazy, man. I'm lucky to be alive today because same police officer harassed me twice in 2 weeks, beat me up, and I'm here because of this.
Well, here's the thing. Are you unless you're saying with this case, police officers planted drugs on you, you are still guilty of possession, and those issues have to be addressed.
So does that give them the right to beat me up?
No, it does not. Here's the thing. What I'm trying to explain to you is there are 2 separate issues that you may have. 1 is you're on probation. I've given you conditions. 2, you say the police treated you badly. That's something that you handle on the civil suit. That's not something that you come to me and say, I don't want to go to inpatient treatment because the police officers beat me up. Is there anything else?
That's it. I mean, guess I have to go with the inpatient treatment.
All right, so you can do inpatient treatment, or either I can send you back to felony drug court. What do you wish?
I'll go back to felony drug court.
All right, Ms. Abrams, can you see if felony drug court will accept him back? And that's to happen while in custody. If they say no, then he's to go to inpatient treatment according to the TAP recommendations. All right, thank you.
Thank you.
Thank you. All right, we're going to go on the record in 2019 CR 10379, State of Texas versus Christopher Caballero. Can our parties announce for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Ruben Gisana for the defendant.
And are you Mr. Caballero?
Yes.
All right, you're requesting back the following property: a loaded Springfield Armory XD9 9mm handgun with 1 magazine and 12 live rounds, a Sega 7.62mm rifle with 1 magazine and 10 live rounds. And it's the court's understanding that cause number 2019 CR 10379 was dismissed, but it was dismissed because this was a pretrial diversion. Is that correct?
That's our understanding, Judge.
All right. Are both parties ready to proceed, state?
Yes, Judge.
Defense?
Yes, Judge.
All right. State, are you in agreement with the returning of the property?
No, Your Honor, we are opposing returning the property. This was, again, as the court already mentioned, this was a part of the pretrial diversion program. As a policy, our office disapproved returning firearms.
Our policy is.
To oppose returning firearms.
All right. Defense?
Your Honor, simply for the fact that the case was, he did resolve this case appropriately. He was successful and the case got dismissed. We don't see any evidentiary value or any reason other than just the desire to take his guns away, necessary in this particular situation. He did buy those guns. They were under his name. He purchased them legally and had no legal reason why he couldn't own guns at the time. They were, seized during the search of his home. However that might have been conducted, but we would just ask that if he could have his, personal property that he spent money on returned to him.
All right. So what is the essence of a pretrial diversion? Is pretrial diversion, you committed the offense, but you are being given the chance to do classes or whatever that's asked of you. And if you complete those, then your case will be dismissed. Is that the crux of pretrial diversion, or is there something else involved?
I'd say that's a good majority of what is required. The only thing is, I think it's just a set term and then some community service hours.
All right.
Your Honor, as you describe PDD, that's how I understand it. I do understand that as your job is also to administer, punishment as you see fit or enforce the laws. And in this particular situation, he completed his course, his pretrial diversion successfully. And as far as any further rehabilitation or further punishment, I just don't see his guns, being kept from him, being a problem, since this case was a possession of a controlled substance case. While guns could be
With
involved,
intent to
they're-
deliver 4,200 grams,
Yes,
which
Your
is a
Honor.
first-degree felony?
I would like to mention they weren't on him at the time or anything like that.
Were they at his home?
Yes, Your Honor.
All right. So does anyone have any case law that says the court is required to return these weapons?
No, Your Honor, that's your decision.
All right. Does anyone know if any case law exists?
Off the top of my head, I'd say no, Judge. I'm not aware.
All right. So if you all would like to have a chance before I make my ruling to see if their case law, I'm not aware of case law that says if someone completes a pretrial diversion, that the weapons that were seized are supposed to be returned. I can understand, and there will be no issue with the court if the case were dismissed or if there was a jury trial and he were found not guilty, then I could understand. But pretrial diversion, even though it's pretrial diversion, it's really sort of a form of probation without the overview of the court, because you still have conditions to do. And if you complete those conditions, then the case will be dismissed. As opposed to, say, for example, if the search warrant were a bad search warrant or were an illegal search warrant and the state dismissed it, then the court can understand automatically you should get your items back. So if you all would like to come back on, let me give you all a date. If you all will come back on the 20th, I will make a decision on whether or not to return the weapons. And if you all have any case law for me during that time, I'll review it.
Yes, Your Honor. Would you like that e-filed as a memorandum?
Oh, you
of
can,
law
you
or
can,
this?
you can email it to, I know how it is to do memorandums of law. I've been a defense attorney before. It's like, Judge, can I just hand you the case law? No, if you just have case law and the state has my email, and I know your office has my email too, you can just send it to me, the case law you have by email, and I will review it. Just make sure you include the state in that email.
Absolutely. I appreciate it.
All right. And then, sir, you can attend the hearing if you want to in person or by Zoom.
Okay.
All right.
And I was wondering, does that mean that I can't also purchase guns in the future, or because since I'm not, or since you're deciding if I could get these or not?
Well, here's your issue that you're looking at, and you'll need to speak to an attorney. The issue that you're looking at is that you were placed on pretrial diversion, and whether or not you're allowed to purchase guns or whatever will depend on what the implication is of your pretrial diversion. All right, so I'll see you all back on Monday.
Thank you. Your Honor.
Thank you. And counsel, if you don't have my email, the state will be able to give it to you.
We're not here on it.
No, the 20th. I know I said money, but it's Tuesday, the 20th. Thanks. All right. And are you Michael Williams?
Yes, Your Honor.
All right. You entered a plea of no contest on April 25th. There was sufficient evidence to find you guilty. The court ordered a PSI. According to the plea bargain agreement, there's no application for deferred adjudication. The state opposes your application for community supervision. Punishment is to be assessed at 3 years in the prison. It's to run concurrent with County Court Cause number 689077. And they will take in consideration County Court Cause number 699697. And the offense is unlawfully carrying a weapon with a felony conviction. All right, have both parties had a chance to review the PSI report, state?
Yes, Judge.
Defense? Any objections to the PSI report, state?
No, Judge.
Defense?
No, yeah.
All right, state, do you have any witnesses?
No, Your Honor.
Defense, do you have any witnesses?
Yes, I'd like to have the defendant speak, and I would like to speak on his behalf.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Michael Williams.
You're gonna have to speak up.
Michael Williams.
All right, defense?
Okay. Michael, you know that you weren't supposed to be carrying a gun because of a prior conviction? Yes, sir. Okay. And what actually happened? You were on your way home from somewhere?
I was on my way home from my aunt's house and I ran into a female friend of mine. It was New Year.
Were you walking from your mother's house or from your aunt's house?
Yes, sir.
Okay. You ran into a friend, a lady, a woman?
And she asked me to check her firearm for her because she was getting ready to go. I guess she was going to go sell it.
She's going to what?
I guess she was going to go sell her firearm and she didn't know if it worked or not.
Okay.
So I checked it for her.
So was it loaded already?
Yes.
Okay, so how did you check it then?
I shot it in the air.
You what?
I shot it.
Shot it in the air. Okay, and that was the basis for your arrest?
The base for my arrest was, okay, so she had to leave and go to her parents' home. I was gonna take her firearm to the house for me and hold it for her. So the officer stopped me. Someone had called in the shot. The officer stopped me and told me he got a call. And he got me with unlawful carry.
What do you mean that the police had got the call about somebody firing a firearm?
Yes, sir.
Okay. And so he stopped you and you had the gun on you still?
Yes, sir.
From the lady that you had met?
Yes, sir.
Friend? Okay. All right, so you had you were gonna hold it for her?
Yes, sir.
Okay.
Got
All
that
right,
to me.
all right. Yeah, I'd like to consider this and from the fact that there wasn't that much malice in his carrying this, it was something that he hadn't expected.
Oh, just 1 second. State, do you have any questions?
Let's see, okay, all right.
State, any questions?
Yes, sir, is it true that you were on probation for burglary of a vehicle second in this file?
Yes, sir.
And isn't it also true that you never reported the probation for that offense?
I had complications reporting. I did try to report, but I had problems with my phone and the Zoom.
Did you attempt to go in person?
No, sir. I did call and make an appointment, but I didn't make it.
No further from state.
All right, any further questions, council?
And no further questions, I'd just like to speak on his behalf.
Yes.
Okay, Your Honor, I'd like to consider in the PSI where it shows that his upbringing was a problem. He had no help from his father. He was brought up by his aunt and his mother, but he had a lot of psychological problems and depression. And he only went through halfway through school. And then he was not very employable. So for the last 7 years, he'd been unemployed. And I think that idleness also set the scene for his drug addiction and alcohol. But he quit the alcohol in 2014, but he continued on some other drugs and he hasn't had those in the last 6 months.
All right, just 1 second, counsel. Mr. Williams, I'm going to give you a choice. Here's your choice. I can give you probation, but you're going into inpatient treatment, or either I will sentence you to 2 years in prison. Now, they say that you have mental health issues and that they're recommending MIOF. MIOF is inpatient. Now, you can go to prison for 2 years, do your time, you're done, or either you can be on probation out of this court.
Recommend you go probation.
Well, no, counsel, this is what I would always tell my clients. I'm not the person who's going to be doing probation. He will. And he knows better than I do, better than you, and better than anyone else, whether or not he can successfully complete probation. So far, what I've seen in his history, he cannot complete probation. But I understand that there are mental health issues going on because in the possession case for his previous conviction, I saw that there was a transfer to MIOF. And then he ended up failing that and ended up going to prison. So you know yourself better than I do, better than your attorney does. Deputy Laura always tells everybody probation in this court is not easy. So your choice is, and there are only two choices. One, I can send you to prison, or two, you're going into inpatient treatment and you're going to MIOF. Either way, you're not going home today. So which do you choose?
I would say, due to my current addiction, I was on heroin. I would say I need an inpatient. I would like to take the probation.
Okay. All right, the court is going to sentence you to 3 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. The UA hotline. We can do a referral to felony drug court. That will be in custody. If he's not accepted in custody, I see here that they're recommending MIOF. That's what they have in there, that he's eligible for MIOF. So if not felony drug court, then MIOF. And then if MIOF is not going to, if felony drug court doesn't accept him and MIOF doesn't accept him, then we'll do SafeP. Proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits one time per month until further notice. 200 hours of community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
14, 13, and 11.
Are you in their life at all?
Not at this time.
That's either yes or no. Have you been an upstanding father in their life, someone they can look up to?
I have, not
How?
recently, but I have.
All right, there's going to be parenting classes. This to run concurrent with County Court Cause number 6890077. Taking consideration 6996697. And then there will be the UA hotline. Counsel, you're hitting the microphone.
Hold on, sorry.
The UA hotline until further notice. Probation, is there anything else he needs? Is there anything else you need from me to be successful? I'm sorry?
No, ma'am.
All right, and so the MIOF, the felony drug court and SafeP, that's to be done in custody.
John, I think he's going to need a lot of help with getting employment. He hasn't had any, and he has his psychological problems as well. So
When's the last time you had employment?
2008.
All right, so you haven't really been supporting your children. All right, and with regards to employment, there's to be no employment as a home health care provider or with minors. If you are planning to be in your children's life and be someone they can be proud of, you're going to have to do better. If you're not going to be in their life on a permanent basis and just breeze in and breeze out, then you need not be around them. You understand? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Mr. Alexander, did you pass that to him? Did you sign that? Did you review that with your attorney and did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you.
All right, thank you.
You're welcome.
thank you.
Probation, this is an application. Court is calling 2023 CR 0889, State of Texas versus Stephen Wayne Walbarker. If I could have parties announced for the record for the state. Defense.
Ron Ross.
And are you Mr. Walbarker? Counsel, have you received all the discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Walbarker, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, you're gonna have to speak up.
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count one, proceeding on count two, and then waiving the enhancement paragraph.
Any objection?
No, Judge.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count two, you're charged with the offense of possession with intent to deliver?
I think that was count one, Judge.
It was count one.
Oh, we need to change that. Any objection to the court changing? Okay.
No, Judge.
Did you understand in count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams, if y'all can initial.
Yes.
That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea, thank you, will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Wahlberger, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. The state is silent on your application. They will take in consideration 2023 CR 0888. Did you understand that to be the plea? Defense? State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Yes, ma'am. We got a motion to suppress.
Okay. Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offers State's Exhibit 1 and all attachments.
No objection.
You may be excused. Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. This will come back on August 10th, and that's when your PSI report will be completed. The court will base its decision on your application based upon the PSI report, which is a pre-sentence investigation, and any other evidence that's presented to the court. Counsel, is a TAP requested as well? A TAP evaluation?
It's not needed, I don't think.
Okay. Do you need a TAP evaluation? Do you have drug issues?
Yes, ma'am. I do.
All right. All right. So we'll do TAP evaluation. So Ms. Abrams, it'll be a PSI and TAP. All right. Thank you. Ms. Ferguson will give you a reset form, and then before you leave, you'll need to speak with probation, so they'll give you instructions.
One more thing,
Yes.
when you denied the motion to suppress, I asked for findings of fact and conclusions of law, and you said you might have that by the time we.
Oh, it's already been filed.
Yeah.
Yes. So they'll be able to print that for you. All right. What's happening with this case?
Good. We conferred this morning, and I got an offer from the state for the first time that's going to probably take care of a couple misdemeanors as well that I don't represent my client on this. My client, I represent him on the felony. I don't represent on the misdemeanors. I would like to get appointed to the misdemeanors so we can take care of all of it together, as well as my client's going to consider the offer, and I'm going to discuss with his family, and we'll have a decision on the state's offer we got today by the next day.
All right, Ms. Ferguson,
Yes, ma'am.
on Anthony Cantu, can we recall this next week for a plea deadline date?
I have a vacation on file, letter on file for next week, Judge. The week after is fine. Pick any day is fine. So anyway, from the 26th to the 30th.
All right, Ms. Ferguson, put this at the beginning of that week of July.
I have a vacation letter for the first week of July as well, Judge. The second week of July is open. That's the 10th through the 14th.
All right, this is an unauthorized use of a vehicle, so I'm assuming there's a lot of discussion that needs to be had on an unauthorized use.
There is a unindicted case, Judge, that the state would not file if we took care of this, so my.
What's the indicted case?
Judge, there was potential that he could have been charged with aggravated robbery as a party.
So we're actually having major conversations about an unauthorized use as opposed to maybe not having an aggravated robbery charge.
So I just conferred with I just got the offer this morning, Judge. I conveyed it to my client and so he is going to just not long, if I could just get till the 26th. That's about a week. If we could just get that long so I can meet with him.
Norma, do we have anything on the docket for tomorrow or no?
I'm going to be in Kendall County tomorrow morning, Judge.
Well, this is Bear County. It starts with a B. Kendall starts with a K, so this one tops that. All right, Norma, can you bring this back on July 10th?
Yes, ma'am.
All right, the court will not accept any plea bargain agreements after that date. Do you understand? All right,
Thank you, Your Honor.
you're welcome. Otilio Espinoza Ruiz,
Good morning,
good morning. Who's the prosecutor on this? Is injury to elderly?
Mr. Escobar. He's on his way up there.
All right, do you have all the discovery now?
I just received some additional discovery this morning, Your Honor, in the form of some discs in my flash drive. I just need additional time to review that with Mr. Espinosa, and then we'll confirm with the state and see if any resolutions may be made.
All right, and state, have you previously tendered an offer?
So
There was an offer in there, Your Honor. So I'll review that with Mr. Espinosa as well.
All right, Ms. Ferguson, on Espinoza, if I can have a 3-week reset for a plea deadline date? All right, July 8th,
Yes, ma'am.
that will be your plea deadline date. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Yes, ma'am. Thank you, Your Honor.
You're welcome. All right, everyone, the court is going to take its lunch break at 12, so everyone move with the plan and the purpose. Is it Christian?
Yes.
All right, thank you. Christian Chavez? Robert, I knew once I made that announcement, everybody would start.
I was just sitting there zoning out. So Judge, this is my first setting.
Okay.
I gave notice, but it didn't show up on the system, not surprisingly enough. So I emailed a copy to Norma and I talked to Jason about some discovery issues. I have to pick up med records.
All right, Ms. Ferguson, on this case, since I noticed that there are medical records, give me a reset for discovery for 45 days.
Perfect. That works perfect for me.
All right, we'll be back on August 1st. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome. Now that you put that in the universe, it's probably going to take a week.
They had 716 people waiting for me Friday morning.
Oh. Are the attorneys here on Joseph Ramirez? All right. And who is his attorney? I'm sorry, you're his attorney. Who's the state?
I can't remember his name. He's bald, but it's not.
Jason?
No, not Jason.
Andrew? All right, just have a seat and we'll take your case up as soon as they.
And just FYI, Judge, it's an agreed. Like as
Oh,
far
I
as-
know, I still, for legal reasons, I still have to put certain things on the record. All right, as soon as they come in, just approach. All right, we'll go on the record. The court is calling 2023 CR 10492, State of Texas versus Renee Rodrigo Esparza. Can I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Tim Roundtree.
All right, and are you Mr. Esparza?
Yes, Your Honor.
All right, the defense has filed a motion for continuing permission to travel for business. Do you have any objections, state?
No, Your Honor.
All right. All right, then the motion will be granted.
Thank you, Judge.
Thank you. You're welcome. Schumacher, hello.
Morning, Judge. How are you doing today?
I'm doing okay. I remember this case. Did you bring the motions for me?
I spoke with the coordinator. I can go get a copy of them real quick if the court would like them.
Okay, because yeah, I need a copy. I don't have one in my file.
Sure, that's what I was checking on. So let me go get that real quick for you and then we'll be ready.
All right, sure. Just have a seat.
Thank you, Judge.
Whenever you all are ready, I'm Mr. Solis. Let the court know. Oh, and Kelly, your client is not to leave until you all sign the form. You have it? Thanks. Good morning.
Good morning.
What's happening with this case?
Governor, if I may, I was supposed to be here on Tuesday. You allowed me to go to Hondo. And I appreciate that. My client came in today. It's our first setting. This is a violation of reporting, and my client had reported for 10 years. There's a discrepancy of whether there's a 10-year reporting or a lifetime out of a Michigan judgment that I would ask if I could get a reset to do a little bit of discovery to see what actually happened in Michigan. I can't tell from this.
All right, which county is it out of?
St. Clair. St. Clair.
St. Clair. What state? I mean, what city is St. Clair?
for you in Michigan, St. Clair County.
Oh, Michigan.
Yes, ma'am.
Ah, all right. And State, I'm assuming you have some information on that.
The state's discovery.
Because I think in the state will need it if they indicted it. So,
There's a judgment in there, Your Honor, that I can't read.
Yeah, I mean, according to the prosecution guide, the duty is a lifetime duty, and so that's the confusion is the detective. Is like with that, and trying to find.
all right, Ms. Ferguson, recall this for 45 days and you all need to have that figured out by then.
Thank you.
Yes, sir. Thank you.
All right, just 1 second. What date?
Discovery, just right over research.
It's for discovery for them to get the judgment out of Michigan.
August 3rd.
All right, we're going to come back on August 3rd, sign the reset form, and then you're excused.
Okay, thank you, ma'am.
All right, thank you.
Thank you, Judge.
You're welcome. And if it's not printed correctly, I'm sure if you all call the prosecutors in Michigan, they will fax or forward or email you all what they have.
Thank you.
You're welcome. All right, where are we on the discovery?
I think we've got it licked, Judge. I talked to the prosecutor this morning. They have it in their possession. I need to deliver them a external hard drive. It's photographs and stuff. So it's a big file. But I think he said it's about 180 gigabytes. So I don't know how long it's going to take me to go through it, but we're definitely over this hump. So we're in good shape.
All right, Ms. Ferguson, on this case with Maldonado Rivera, State, when will you be prepared to make an offer?
They have made an initial offer, Judge, but that was without us, going through.
Oh, so State, you've already made an offer?
I believe an offer's been made. I think we're coming back today because we were trying to get a cell phone dump, and the state has received a drive with that dump. And we've informed defense that if they provide us with a drive large enough for the dump, we can put it on their drive and get that.
All right. So Ms. Ferguson, on this case, thank you.
Yes, sir.
On this case, Ms. Ferguson, give them a 45-day reset for a plea deadline date.
Thank you, Judge.
Oh, well, you need to date, don't you?
Oh, well, thank you again.
Hey, I got 2 thank yous in one
Hey.
day.
Better to be nice.
I can do August 1st.
All right, we'll come back on August 1st. August 1st will be your plea deadline date. At that time, you need to let the court know whether or not you're accepting the state's offer. You understand?
Yes, ma'am.
All right, thank you.
Thank you.
All right, so today is for discovery.
Yes, Judge. Right now, the CPS.
It's Caleb Crum. There you go. Yes.
CPS records, I think they're burning them to a disk to get to me. And
Okay.
they have subpoenaed APS to get me the file that we talked about last time, but right now we still don't have those. They're in the works essentially. Hopefully we can have one more discovery.
So what
setting.
don't you have?
I don't have the Adult Protective Services record for one of the witnesses / maybe complaining witnesses. And then I don't have a CPS case involving him. That was the notice of additional discovery. I should have that one sooner rather than later though.
And that is correct, Your Honor. The subpoena is out on the Adult Protective Services records, and on the CPS records, it's just a matter of getting them turned to the disk, which I have noted
Okay.
a little reminder to do that after this docket so that we
Okay.
can provide them immediately.
All right, so is 45 days enough time for the Adult Protective Services?
I would think so, and I would think I'd have enough time to review them. It just depends on how thick the file is and assuming they do come back.
All right, Ms. Ferguson, I need a 45-day reset on Crum for discovery.
I can do that one on August 3rd. Yeah.
All right, August 3rd.
Thank you, Judge.
Once you sign the reset form, you and your client are excused.
Thank you, Judge. Appreciate it.
You're welcome.
Oh, Judge, sorry, one more thing. Last time you made mention of the fact that my client looked a little bit fidgety. He mentioned the fact that he had been prescribed THC. You asked for
Yes.
the documentation. I have that here today. He stopped it.
Okay.
In an interest of just being as safe as possible until we discuss it with you.
Okay.
Since that happened, he did have another epileptic seizure.
Mhm.
There are seizure medications available to him. They're much more expensive. They are much more harsh on his body.
Well, no, here's the thing about that. Whoever is testing him, whether he's using marijuana or not, I know that there is medical use that's allowed for marijuana. He just needs to make sure that he has that. Otherwise, he's gonna have
Put
problems.
all the cards on the table for you.
All right. Thank you. State, do you need to see this?
Defense tendered those to the state and the state has.
All right, thank you. Thank
You
you.
want those for your file?
Yes, I'll keep them.
Thank
And once you sign the reset your excuse.
Thank you, Judge. Appreciate
You're
it.
welcome.
I'll go and make them now.